Apologies for the wait. We will now begin. Esteemed visionary participants and distinguished members of the audience, it is with immense pride and exhilaration that I stand before you as we culminate an inspiring journey of intellectual exploration at the grand finale of the AI and IPR debate competition, proudly organized by the Uttar Pradesh Legal Rights Consortium. I, Adrika, the state president of Uttar Pradesh Legal Rights Consortium, once again have the distinct honor of serving as your host for this momentous occasion. Over the past rounds, we have witnessed remarkable displays of critical thinking, persuasive articulation, and a deep engagement with the complex intersection of artificial intelligence and intellectual property rights. Today, we gather to witness the final clash of intellect, where the most compelling arguments will rise the forefront. This grand finale is not merely a culmination, it is a testament to the power of dialogue in shaping our understanding of the evolving legal landscape. It is a celebration of the courage to question, the regard to research, and the eloquence to articulate a vision for the future. Before we commence today's eagerly awaited debate competition, I would like to address a matter that weighs heavily on our hearts. Our nation has recently been struck by the tragic and senseless violation in Pahalgam, where innocent lives were unjustly taken. These were individuals with aspirations, narratives, and everyday lives that were abruptly ended. I salmon, in solemn remembrance of these precious souls, and with deep for their families, I respectfully request that everyone rise and join us in observing 2 minutes of heartfelt silence. Let this silence serve as a profound expression of our collective grief, our unwavering remembrance, and our enduring hope for peace and the sanctity of human life. Thank you. The Uttar Pradesh Legal Rights Consortium, operating under the aegis of National Legal Rights Consortium and the esteemed Women's Indian Chamber of Commerce and Industry, stands as a dedicated advocate for legal awareness, empowerment, and justice, particularly for women and marginalized communities. We are committed to bridging the divide between legal principles and tangible justice by ensuring legal rights are accessible, actionable, and effectively reinforced. Our initiatives encompass widespread legal literacy programs in various institutions. We also leverage online platforms to broaden our reach and foster crucial dialogues, recognizing the power of active engagement. UPLRC organizes interactive events like the debate competition to cultivate critical thinking and legal action, striving to build a society where legal rights are understood, exercised, and defended. At our core, UPLRC believes that informed citizens are empowered citizens, and we are dedicated to fostering a just and equitable legal environment for all. We step into the final round of the online debate competition hosted by UPLRC. It is my absolute privilege to introduce the remarkable professionals who will be judging today's event. This isn't just a It's a powerhouse of legal expertise, diverse insight, and lived experiences in the very theme we are debating today: artificial intelligence, intellectual property right, and the legal framework of the future. First, we welcome Ms. Rishita Pandey, an accomplished IP intellectual property associate at RVR Associates, Hyderabad. Her specializations spans the critical thinking of trademarks, patents, copyrights, and design law. As a silver medalist from ICFAI University, Dehradun, her passions for protecting innovation and creativity is evident in her diverse experience, ranging from trademark prosecution and patent drafting to client consultation and IP awareness initiatives. Next, we are honored to have with us Ms. Kriti Goyal, a corporate legal counsel at Teleperformance, with a master's degree in business law from Sorbonne Law School, France, and a keen interest in technology, policy, and international commercial law. Ms. Goyal brings a unique blend of legal expertise and practical business insights. Her work involves high stakes legal documentation, cross border agreements, and strategic advisory, reflecting her commitment to ethical lawyering and innovation in the legal domain. And finally, we are delighted to welcome Ms. Anwesha Banerjee, a media and entertainment lawyer at A&M Global Mumbai, a graduate of NMIMS Mumbai and a master's degree in intellectual property and technology law from Jindal Global Law University. As Ms. Banerjee, practice focuses on intellectual property rights, artist and film production, music deals, privacy laws, and the evolving role of AI in entertainment industry. Her work with prominent Bollywood and Telugu films productions brings a unique perspective to our deliberations today. The topic for this grand finale remains the thought provoking and timely question: liability for AI generated infringement. Should AI be held responsible? The teams competing today are TC04 arguing for the motion and TC05 arguing against the motion. The format for the final round will be as follows. Each team will have a total of 10 minutes to present their arguments. The format is as follows. First, the opening arguments will be made by the team for the motion, followed by the opening arguments made by the team against the motion. Then, the rebuttal will be made by the team for the motion, followed by the rebuttal made by the team against the motion. Then, in the end, first, the closing arguments will be made by the team for the motion, followed by the closing arguments made by the team against the motion. The teams are requested to start with their arguments once I have displayed the stopwatch. I hope my screen is visible.
Yes, it is.
Thank you. I would like to explain that the timer towards the left is for the team for the motion, and the timer towards the right is for the team against the motion. Uh, team, you begin with your opening statements. PC04, am I audible?
Ma'am, we are against the motion, so should we go first?
Sorry, TC04, you are for the motion.
Just a second, ma'am. Just a second.
Yes, no issues.
Ma'am, my speaker two will go first, and then I will be going. If that's fine.
Yes, no issues. Please, you can start with your arguments.
Counsel. This is TCO 4 Speaker 2, and I'm excited to speak for the motion on why AI should own the responsibility to its actions. Establishing responsibility to AI should not be misunderstood as stifling innovation or being anti artificial intelligence. It's about being responsible and fostering a conditioned growth. I would firstly address the why on why should we make AI liable. Moving on to the how later. Unfortunate cases that have arisen revolves around one of the cases were the Belgium case where talking to an AI chatbot named Eliza, the chatbot abetted a man to take his own life to quote save the planet unquote shows the possible effects of AI on the human minds. Another case revolving around a professor as he searched up his own name on the AI chatbot revealed false allegations of fraud against him. Um, who is to be held liable for these blatant criminal or civil wrongs? Recognizing this gap, uh, European Union enacted the new Product Liability Act of 2024. Similarly, US Senate enacted AI leadership to enable accountable use of AI last year. My second part of my arguments revolves around how to implement AI specific laws and how to hold them liable. AI models cannot fit into traditional models, such as rigid jargon, such as causation, breach, etc. Because one of the problems is unless the software is embedded into the hardware of the system, the product could not still uh, the software would not qualify as a product at escaping consumer liability. Similarly, it's hard to ascertain mens rea to an AI model, uh, actus rea, actus rea being the easy one. A way to rectify this dilemma is for using the self-driving cars model for liability. The requirement for mens rea is abolished when we use strict liability principles. Using strict liability for AI would hook these developers for any damages caused by their AI models. AI should abide by the guidelines the same way every other right given to us has a reasonable restriction. Thereby, I rest the arguments for my side.
Judges and my learned opponents, let's stop pretending that artificial intelligence is just an innocent bystander in the creative process. When an AI model like Sora generates near exact replicas of Studio Ghibli's iconic style, that's not inspiration, that's imitation at an industrial scale. And if that imitation is built on a scrap copyrighted content without consent, there's no excuse for sidestepping the accountability. Saying blame the developer is like blaming a parent for everything their adult child does at some point. The creation becomes independent and impactful. AI is no longer just a passive tool. And yes, it generates the content by its own self. It curates, it learns, and yes, it is still generating its own content. We all today are using these AI tools in our daily lives. Chat GPT, DeepSeek, all of these are being used by us. If it if its outputs harm the original artist, dilute their market, or profit their years of labor, then somewhere something must be held accountable. And if not the AI directly, then its output must be regulated like any other commercial content. There are major amount of sections in the Copyright Act dealing with computer generated programs, say Section D of Copyright Act of 1957, Section 2 FFC, which are talking about computer generated programs. So it is very easy for us to add the artificial intelligence into these legislation so that we are actually able to build a world where we are being inclusive to artificial intelligence. There are multiple amount of journals that are existing in today's time, international journals, which are ready to actually accept artificial intelligence into being a co-author in these cases. And therefore, if we are actually granting them the rights of copyright, why are we not actually holding them liable for the same? I rest my case.
TC05, you may proceed with your opening statements.
Shoma, am I audible?
Yes, you're audible.
Or- Responsibility implies consciousness, accountability demands intention. Can a machine ever intend or only execute? A very good afternoon to the esteemed adjudicators, my worthy opponents, and a marvelous moderator, Adhika. I, speaker one of Team Code 5, along with my insightful co speaker, rise in strong opposition to the motion and points that AI should not be held liable for intellectual property infringement. Before starting, I would like to sincerely thank the learned opposing counsels for their well articulated arguments. Interestingly, all the points raised by them concerning autonomy decision making, they lend support to our position that liability should indeed rest with creators and not with the AI. Their arguments underscore the fact that human agency and legal accountability remain central. I'll presenting the first 3 minutes of our argument, following which my co-speaker will carry the discussion forward. Without wasting any of the time, let's first begin with what we all agree on. AI is important, AI is powerful, AI is the shiny new guest at the legal table. But let's not get carried away. It's still a guest, right? Not a citizen, not a legal person, and certainly not someone you can drag to court. Because here's the thought, no matter how futuristic it sounds, it's legally and logically impossible to hold AI liable for IP infringement. And I'm not just saying this, I'll show you why. Backed by law, precedent, and principle, the entire machinery of liability, whether civil or criminal, functions on one condition, that there exists a legal person, someone who can owe a duty, breach it, be sued, fined, or punished. And AI does not qualify, it does not even apply. If we look at the Section 2 of the Indian Copyright Act, it clearly defines an author as a natural or juristic person. The Supreme Court in Narendra Kumar versus Union of India reaffirmed that enforceable rights and liabilities exist only against person. So unless city starts hiring lawyers and voting in elections, AI simply does not fit in this bill. Now I would like to revisit to our basics. So liability isn't about what happened. It's about why it happened. Mens rea, the guilty mind, they are the fundamental, and they're not just fundamental in criminal law, but also in establishing willful infringement in IP cases. In the landmark case of super cassettes, the Delhi High Court ruled that platform liability requires knowledge, control, and intent. So let's play this out. Are we truly ready to believe that AI software maliciously decided to remix Taylor Swift's lyrics and sabotage her new album? No matter how advanced AI operates on code, holding AI liable is equivalent of jailing a microwave for burning your dinner. It's very absurd, right? So here's the kicker. We already have a liability structure. It's called human accountability. Section 79 of the Indian Act discusses this liability, which holds the developer, deployer, or the user responsible. In the case of Getty Images versus Stability AI, the court did not sue the AI for lifting the images. Getty went after the creators of the model. So, really, why reinvent the liability? Let's even take a real analogy. Let's say Tesla, an autopilot, runs over a pedestrian. Now what? Do we haul the car to jail, impose a fine on the tires, or my personal favorite, give it a death penalty by scrapping its parts? Clearly, we cannot do any of them. We have to sue the manufacturer. And why this basic framework in place? I'll request the honorable panel to allow my co-speaker to now explore and build further on our stance. And thank you.
Thank you, indeed. Building upon that solid foundation, let's now turn our case to the international legal landscape. Let's be clear. The world may not agree on pineapple on pizza, but here's something it does agree upon. AI is not a legal person. WIPO's 2021 report on AI and IP spells it out. The concept of legal personhood for AI is currently unsupported by global consensus. The European Union's AI Act places responsibility on providers and deployers, not the algorithm, not the circuit board, and definitely not ChatGPT's third cousin. Even China, portrayed as wild west of tech policy, assigns liability to humans. The 2020 copyright guidelines make it crystal clear. Across the Atlantic, human authorship are even eligible for copyright protection or infringement. Let's entertain the idea for a second. What happens if we try to hold AI liable? Do we send ChatGPT to jail, confiscate its training data, or put ChatGPT on house arrest with ankle monitors. In the R.G. Anand case, the Delhi High Court stressed that originality and infringement are grounded in human creativity, which is central to being a human. The moment we try to hold AI directly accountable, we rip apart the entire enforcement chain. Allowing AI to bear liability will create a legal vacuum. Now imagine giving AI the status of a liable entity. But a dream come true for developers who want to dodge responsibility. Take Universal Music Group case. The allegation AI reproduced copyrighted lyrics. Had AI been legally liable, the creators could have shrugged and gone. Letting AI take the phone is like opening floodgates for evasion, dilution of corporate accountability, and the magical vanishing act of legal responsibility. At the core of liability lies a simple principle: those who benefit, control, and intend should bear the burden. AI ticks none of those boxes. So, why should it shoulder the punishment? To quote Professor Pamela Samuelson, one of the most reputed voices in IP law, assigning AI the burden of infringement without capacity to comply or respond creates dead ends in enforcement, not justice. Liability without accountability is just a legal theater. With this, we would like to rest our arguments and thank the honorable panel and everyone else for the opportunity.
Thank you. I would now like to request TC04 to move forward with the rebuttal.
So, as our learned opponents were arguing about, first point was about nationality. I hope my learned opponents are also aware about Sophia Robot, who was granted a citizenship in Saudi Arabia. If we keep our mindset so concise and we don't actually come to an update, an upgradation, we'll never be able to actually become a developed country. If Saudi Arabia can do it, India itself can also bring legislation amendments. The word amendment, why did it come to India? Why do we have amendments? It is mainly because we as India, we are a developing country. We need to develop. We need to take the technology into our country, and that is how we'll be actually be able to come under the developed countries. And therefore, if we actually stop and start being scared about every kind of nitty-gritties and litigations that will come into consideration, we'll actually stop actually holding accountability of the artificial intelligence itself, because here the blaming game starts. Now if we as Indians do not actually have an artificial intelligence law like European Union has, how will we place the liability? OpenAI, if not blamed for whatever infringements that are taking place, if the artificial intelligence itself is not being blamed, in that particular case, who will be blamed? The makers. The makers cannot be blamed all the time. As I earlier also stated in my opening argument about the Ghibli trend, there are so many vast amount of people who were actually making these Ghibli trends, but it is not the fault of the person who's making it, because it was just a trend. We are just normal users. We don't know the legalities, and therefore it has to be the AI that needs to be held accountable for these things. We cannot go on blaming the nationals of our country itself. Another thing is about the corporations. Like the corporation, there is corporate wheel inside, there are people who are working inside the organization in a similar manner. It is same with the case of AI. The makers, the OpenAI, or any other kind of company that has to be held accountable. That is something that we have been doing for long amount of time. We have done it with LinkedIn, we have done it with Instagram, we have done it with Facebook, we have done it with X, we have done it with every kind of social media app. If that was the case, if we were actually going into these nitty gritties, then in that particular case, there had to be no DPDP Act that has been present in right now, because then we are not going to go for any kind of development, because then a lot of nitty gritties will come into consideration. So all the points that have been made by my learned opponents are baseless. Thank you.
I would like to add to my co-counsel's argument. I would like to address Speaker 2 from the opposite counsel first. When Speaker 2 mentioned that um, ascertaining ascertaining liability to AI models would open the floodgates by making the corporations um, sort of leave liability. I would like to argue that the opposite is also true, because if in case you do not ascertain liability to AI models, the corporations could use AI models to escape liability in the same way the opposite is possible. Also, I would add to the arguments by saying the complexity of AI systems that makes liability framework more necessary. and not less. Our legal systems have successfully sort of addressed complex liability questions for centuries. Multi-party construction projects, pharmaceutical projects, solutions exist, joint and several liability, proportional liability, and like a lot of different sort of insurance mechanism that spread risks. Everything that has arisen until now, our legal system have sort of found a way to move ahead with it. So the argument that AI systems are too complex to form legal, so it's too complex to ascertain where the liability arises does not really stand out. The EU AI Act specifically addresses this by establishing clear liability across the AI value chain. Complexity is not a reason to abandon accountability. It's a reason to carefully craft appropriate frameworks that would provide clarity to all the stakeholders involved, as my co-counsel also argued, using the Ghibli trend, and ensure victims aren't left without recourse just because we think it's too complex to ascertain liability. I rest my arguments by this. Thank you.
I would now like to request the speakers of TC05 to put forward their rebuttals.
Thank you so much. First of all, I would like to counter TC04 speaker number one, who compared artificial intelligence with an adult child. First of all, as per law, adult and child, these two words don't go together. And after that, an adult is someone who possesses mind, who have consciousness, who have ability to think. But AI, it's not the same. In AI, the mind of the AI is in developers, the one who made it, and that's not AI. Those are the developers. And second, when you talked of amendment is for a meaningful change, for benefit of society, not to ruin the constitutional principles by having the corporations or the developers escape the responsibility. And thirdly, when the speaker mentioned about the link to Instagram, the liability in those cases is on corporation. That well, TC04 speaker 2 misunderstood my point by saying that AI should not be liable. We do not in any mean say that no one is liable. By saying that AI is not liable means that AI, which is simply a tool, nothing on its own, is not liable. The developers, those who are creating it, those who are working upon it, those will be liable. But not AI.
Thank you.
You
Firstly, I
cannot be
would
held
like
liable.
to thank the respected counsels for their passionate arguments. We appreciate your perspective, but we respectfully disagree. And let me tell you the reasons why. Firstly, I would like to answer the question of the case that was cited by my opponent, that the Sofia citizenship case, right? The Sofia citizenship case was purely symbolic with no legal weight. It did not grant actual rights or responsibility. AI lacks consciousness and moral judgment, so it cannot be a legal liability in any case. Responsibility must remain with the humans who create, control, or deploy it. Now, moving to the corporations are recognized legal persons with human directors making decisions. They have legal frameworks governing their rights and liabilities. AI, by contrast, lacks consciousness, intent. It's not even fulfill the requisites of a legal person, and thus cannot be held accountable in the same structured way. Now, I would also like to mention that we have they have tried to create a legal fiction to treat AI like a person. But fictionalizing law does not mean we fix problems. Let's talk about the deterrence. You cannot deter something that cannot be deterred. Because as per the deterrence theory in jurisprudence,
I'm sorry to interrupt, but the time has been exceeded. Would you like to request the judges for extra time?
I would request the judges, respective judges, if they could grant us few minutes to complete the arguments. Thank you so much.
Kindly start once I have reset your time.
Sure.
You may start.
Thank you. As I was mentioning earlier, that if we even look at the point of deterrence, though the opponents haven't mentioned it, but we still consider it. You cannot deter something that cannot be deterred. Because as per the deterrence theory in jurisprudence, punishment only works when the actor can anticipate the consequences and change behavior. But AI does not fear courtrooms. You then, if we look at this concept, then we might also punish gravity for a landslide. So even if we accept this misconception that AI should be held liable, it owes no property, no money to pay damages or settle claims. I would also like to humbly ask my worthy opponent certain questions. A, if AI keeps evolving, how will you even ensure that the version you sue is the one that caused the harm? Would we sue every new update like it's a new criminal? If we look at the personhood, if we grant AI legal standing, what's next? Making ChatGPT a witness? And my personal favorite, and most importantly, when robust legal tools already exist to hold humans and corporations accountable, what real value does fictional AI liability add, except for confusion and procedural chaos? We would happy to hear the opposition's answers and reasoning on this matter. Thank you.
Thank you, TC05. In case TC04 would like to rebut their points, they may do so.
I would like to address the opposing counsel speaker one's some of the arguments. The first arguments being about the deterrence theory. Using that arguments assumes that deterrence, one of the jurisprudence theories, assumes that deterrence is one of the only reasons why liability or punishment in the legal systems exist, but that is inherently a wrong viewpoint to take, in my opinion, because assuming that, as you said, ChatGPT can be a witness, that would also fall under the assumption that when you think of ascertaining liability to ChatGPT or AI softwares, you're assuming that the traditional legal boundaries of what a criminal case would be would persist throughout every liability that you would have to be established in case of an AI software. I think our goal, when we're thinking of ascertaining liability to these softwares, is to imagine a system that sort of transcends the current legal system that exists. Because obviously, AI software do not have the financial initiative. They do not. They don't suffer punishments the way humans can. That's why if we are thinking of ascertaining liability to these softwares, we would need to change the system and think of a new way or a different way to actually hold these liable. Also addressing the arguments of some the other counsel of the opposite teams, said that AI lacks agency or consciousness. Even though AI, I would also argue, would not be equivalent to how a human thinks. AI is still, by the doctrine of uncertainty of how an AI would act. AI does use data models spanning across various thousands of data structures. However, the real, just like how humans act, the real what the AI is going to do next is cannot be predictable, and this has been backed by a multiple of theories. I would also like to include that unlike passive tools, advanced AI systems tend to make independent decisions without human oversight, and that has been proved possible by a lot of cases. The strict liability framework doesn't require consciousness. It recognizes that when entities operate autonomously in society, those who profit from their position should also be held liable for the same. I rest my arguments by these. Thank you.
Next, I'd like to counter all the points my learned opponents made. The first one was about consciousness. So, I'd like to give some information to my learned opponents about the Alan Turing test, if you have known about it. According to that, there was a human and there was a computer, and both of them wrote the same content. And the human being was not able to distinguish between both of them. And that is where, somewhere or the other, though consciousness is not present in AI, but somewhere or the other, the similarity is uncanny and we cannot actually differentiate between both of them. The second point was about constitutional amendment. My learned opponent, I am not just saying that you have to blame the AI itself. The maker, the AI, and the company, all the three should be blamed for it. The third point was about that AI is not a tool. I'd like to state that AI, if it was not a tool, it would have been Google itself. Google would have not made Gemini again and again an artificial intelligence which could make the content as soon as I put it into my phone right now. Another point was about case of Sophia. There was no such case as Sophia's case. It was just that there was this robot in Saudi Arabia in 2017 which had actually granted the nationality, a legal personhood to a robot. And in a similar circumstance, this could be done in India itself. If we are actually going to think about the next point about fictionalization, we should actually see that this is not a fiction anymore. There have been a lot of cases where we are able to see that AI is exactly like what a human being is able to do. Another point that was stated was about evolving AI. So I'd like to state that we'll be blaming the AI itself because every version, like version 4 of ChatGPT, cannot be blamed. We'll blame the AI itself and not any evolving AI. Another point, which was your favorite point about fictionalization and the robust tools, I'd like to state that since the social media also came, Facebook came on in 2004, we have seen that there have been a lot of online sexual harassment cases also. In a similar manner, AI has also developed to that level as social media and maybe 2x more, 10x more. And therefore, the liability needs to be placed for them also. If we actually stop here itself, then there is futile usage and then we'll actually be way too behind other countries. I rest my case here.
Thank you for your counter
With
arguments, TC04. Once again, TC05, if you would like to argue against it, you
sure.
may proceed.
Also, I would like to take the permission that my speaker's laptop is not working. So can she sit along with?
Yes, she can.
Thank you so much. Thank you so much, my loaned opposite counsels, for their questions and the queries they have raised. Firstly, I would like to say that there are a lot of misconceptions that have been raised. For example, Speaker One says that we are not considering AI as a tool, but I would like to mention that I said AI is a tool. Then the Sophia case. You were the one who mentioned about the Sophia case. I thought I was aware about the robot case. So I just said that probably the robot's name is Sophia. So I said that the Sophia case, and then I tried to counter it. Then about the fiction thing, I just feel I just would like to clarify here that if it's not a legal fiction, then what it is? Will you put the Tesla's AI car in the jail, or you'll scrap its parts? This is your punishment. Also, then I would like to talk about that alien theory that you are pointing out. Alien theory is theoretical and speculative. AI may mimic autonomy, but it lacks true consciousness at the end, right? Morals, agency, or legal intent. Mentory is missing at the first place. Liability must rest with the humans programming and deploying the AI, not the tool itself. I wonder if AI, let's say Instagram did something, as you also talked about Instagram, right? Then I had to, you know, make my phone go to jail or present himself in the court, right? Please defend your case. Also, you are saying that along with the manufacturers, the AI should be held liable, but that is practically not at all possible because AI is not a legal person at the first place. Then, uh, another, can you also tell us the name of the act that you mentioned in the very starting that EU enacted that whole AI legally accountable? Because my source say that there is no act as per se in any global in any country that holds AI accountable for intellectual property infringement. So I would love if you could please help me out with this query. Now I would like to pass the stage to my co-speaker. Thank you.
Yeah. First of all, I believe that the opposing counsels are completely mistaken in understanding what the topic of the debate actually means. It's about the liability of AI, not the developers. Now, I'll put forward 2 points which will prove that why we can't hold AI liable. And those points have potential to end the debate. First of all, every legal system have liability on the presence of guilty of first actus reus and then mens rea. AI cannot form intention or understand guilt. It functions purely on data and algorithms. Thus, it is incapable of criminal or tortious liability. Only humans possess the moral and legal agency necessary for culpability. Second, in tort and criminal law, liability follows the chain of causation, if you understand that. We trace the cause of harm back to the party who had control, knowledge, or intent. AI is a tool, not an independent agent. It is the human developer who trained it or the user who prompted it that see the chain in motion. After that, laws exist to guide, to punish, to protect people, not machines. Courts cannot fine, imprison, or morally condemn AI. It cannot apologize, rectify, harm, or reform its behavior. And that's all I would want to say. And I believe that these points have potential to enter.
Also, just adding on to the same, the speaker mentioned that there are various judgments that point out that holds AI legally liable for IP infringement. I would love to know such judgments because I don't think my source say that there's not a single judgment. There was just the Thaler case that happened in Australia that was also overturned by the full judge bench of the Australian federal court that hold the AI liable, and it said that no, you can't hold an AI software liable. Holding AI liable for IP infringement is far off place, and I don't think that can be practical as of now. Thank you.
Uh, Team TC05, you have run out of time. So I would like to request the judges to grant them, if they would like to grant them extra time for their closing arguments.
We would be really honored if the esteemed judges would
Will you be fine with 2 minutes?
yeah.
Go ahead.
Ma'am, could we maybe get 2 minutes and 30 seconds? Because I'd just like to counter the points. I'll not add any
Sure,
points
sure.
to.
Take this.
Okay, thank you so much, ma'am. Means a lot.
Kindly start with the closing arguments once I have reset the time. TC04, you may proceed.
First of all, I'd like to counter my learned opponent that the corporations are also having that they're also having copyrights, and therefore an AI could also have a copyright. Another point is about artificial intelligence. I mean, learned opponents, I know you are talking about restriction of laws, development of laws. I think your knowledge is a little bit restricted when I say that it's not only about always about the fines, and it's not always about the infringement. There could be a stoppage of AI also. Say, for example, if I do some act which is wrong, so I could be punished for it, the company could be punished for it, and the AI that I'm using could also be punished for it by stopping the usage of it for say for say 3 months. So that could be one solution to it. Another thing is about the EU legislations. It's my mistake. It's the Beijing legislations. The China has actually stated that they will be taking copyright into existence and that they will be granting IPR rights to it. Now, coming to my closing statements, why stop now? Why be scared of holding AI accountable when it's no longer just executing codes? It's transforming industries, replacing artists, and disruptive livelihoods. Taking Ghibli's AI controversy, where models copy the iconic animation style without the consent, or the Zaria of the Dawn case, where the US Copyright Office denied copyright because no human authored the work. If AI can mimic with such precision that we can't tell the original from the generated, then it must be held to a standard. We have seen this before. Jason Allen's AI generated painting Theater de Opera Spatial won an art competition, beating human artists. Is that not an impact? When AI writes news articles, creates music, designs, logos, whose rights are being sidelined in this case? We don't let Instagram or Facebook off the hook when they become repeat offenders in copyright variation, as I stated earlier, violation. So why should AI developers get a free pass? And why should AI actually get a free pass? Thank you so much.
PC04 Speaker 2, do you have anything that you want to add on?
Are we proceeding with the closing argument?
Sorry?
Are we proceeding with the closing arguments right now?
Yes, yes. This is actually the time granted for closing arguments. Would you like to add on to the first speaker?
Yeah, I, I would like to start by mini factual addition to what the opposing counsel said. They mentioned that there has been no case where a copyright has been granted to an AI, and they mentioned the Thaler case, where I would like to just mention that out of 17 jurisdictions, South Africa did grant AI copyright. So I would like to proceed with my judges and members, I focus on why and how to make AI liable in my arguments by highlighting the need of why liability needs to be ascertained for AI models. Secondly, the world's leading jurisdictions recognize this inevitably. As I mentioned, the EU New Product Liability Act, where they allow liability and compensation granted to people for AI violations, and US's New Senate's Act, acknowledging the necessity of clear liability rules. It is not theoretical, it's happening now, and it's a practical need of why we need product liability rules. It's not about stifling innovation, as I mentioned earlier. It's about making sure innovation serves humanity, creating the guidelines that are necessary for this powerful technology to develop responsibly. Immunity does not promote progress, it promotes recklessness. Hence, we support the motion that AI should be held liable for its infringements. Thank you so much for listening to all our arguments so intently.
With your permission of the honorable panel, I would like to counter first, and then I would like to move to the closing statement. Can I?
If you can do it in the stipulated time span, then great. Please do it.
Sure, ma'am. Thank you so much, ma'am. Firstly, I would like to counter some of the arguments and some of the points that have been laid by the respective opposite my opponents. Speaker two is saying that talks about the cases where AI held liable for copyright infringement. But I asked for some of the cases where AI liable for the intellectual property right infringement, and how much I am aware, there are no cases where even it is held liable, AI is held liable for the copyright infringement. They have cited the Zaria case where the final judgment was that the AI was not held liable, not even given the copyright. So how can it be held liable for a copyright infringement if it was not even considered author at the first place? Then they have cited one of the legislation of the China, though China is very progressive when it comes to the AI and tech. However, the legislation don't hold AI liable for the infringement of the intellectual property rights. Now, I think I would like to move to the closing statement. Yes, AI is evolving. Yes, it's reshaping the boundaries of innovation. And yes, our IP laws must evolve too. But what we must not do is lose sight of legal logic in the pursuit of digital dynamics. Assigning liability to AI is not modernization, it is a misdirection. Let's not be eager to make AI human like that we forget the very principles to make law a law. As Professor Lawrence once said, code is law, but even then, the law must apply to those who write the code. Let us not remain prisoners of outdated myths. Let's invent new ones to solve the modern problems. Responsibility must remain with the humans, the creators, the developers, the deployers, not with the digital tools. With this, I, Speaker 1, urge this House to reject the motion. I would like to pass the stage to my co speaker. Thank you.
Honorable judges, as we as we reach the conclusion of this debate, let's pause and reflect not just on copyright law, but on how we are as a legal community choose to respond to emerging technologies. AI may be fast, it may be powerful, but it is not a person. It cannot form intention, understand rights, or bear responsibility. To hold it legally liable is not revolutionary, it is legally incoherent. Throughout this round, we have shown that liability flows from personhood, intention, and control. all of which reside not in the code but in the human hands behind it. Let's be realistic. Assigning liability to AI would create a dangerous legal smokescreen, a loophole, not a solution, a scapegoat, not a responsible party. As R.J. Anand case reminds us, originality and infringement stand from human creativity. The legal consequences must follow the same path. Back to the human is control. Now, I would like to say to hold AI liable is to chase shadows. To hold humans liable is to uphold justice. With this, Team Code 5 respectfully rests our case. It has been an absolute honor to present our arguments before this esteemed panel. We thank the adjudicators for their time and insight. Thank you.
Thank you to both the teams for such. Uh, I mean, I'm speechless with the arguments. They were very nice. I would now request the judges to kindly put their scores in the score sheet, as we are not able to see some of the scores. It's a live score sheet, and then we could proceed with the feedback, and and then we can declare the results as well in the meeting itself. So I would like to request the judges to kindly put their marks, and once it is done, let me know.
I'll just go ahead and rename the team names. I think it's written as Team O1 and O2. Instead of that, we are renaming it as O4 and 5, just for our clarity.
Actually, someone just filled the sheet provided to me, I guess. In the score sheet,
Sorry, ma'am. Yes.
in the score sheet, someone filled my sheet instead of theirs. So,
I would request the judges to kindly check the same. Please fill the sheets with respect to your names, which have been mentioned there. There are
because
different sheets.
there are four sheet in the same sheet provided.
We can now proceed with the feedback. I request the judges if they have any feedback for the teams uh, to kindly do so. Miss Kriti Goyal, I would request you to kindly go ahead with the same.
Okay. Thank you. Firstly, thank you so much for having me. And it was a very productive Sunday afternoon wherein I get to see all women panel and everybody very charged up and very enthusiastic about the topic and very aggressively arguing, which I really enjoy. Um, the 3 points that I would really um, mention, the research was good. The the way the arguments were presented, it was very nicely done and very accurately executed as well, wherein you had the rebuttals very they were structured in a very processed manner, like one by one you were rebutting and you were addressing all the points that each team has mentioned, and the delivery and the presentation was on point. However, I felt that I during the whole presentation, there were few baseless arguments that were mentioned, and we could have avoided that and mentioned the latest couple of cases that I have come across. There is one you can like go back and have a look at them. One is Alter versus OpenAI. One is Basteze versus Anthropic, and both of them are on copyright infringement, and they're very interesting cases. So have a look at them, and instead of mentioning your arguments that there are journals and there are certain cases who are giving authority uh, authorization and authorship to AI, we can structure the argument mentioning which all cases and which all journals, because uh, which all journals are actually there existing, rather than having a conversation in air. We will always backed by evidence. It is always backed by mentioning those evidence rather than stating them as sentences and facts. So I really enjoyed um, the whole debate, and it gave me a uh, lot of energy to go back and read also. So yes, thank you so much.
Thank you so much, ma'am, for your valuable feedback. I would now like to request Miss Anwesha to kindly proceed with the feedback.
Hi, everyone. Thank you for the invite. I think some
Yes, ma'am.
says,
Ma'am, am I audible?
so can I proceed? I think somebody was trying to speak something.
Ma'am, you may proceed.
Okay.
Thank you.
Yeah, so just coming back to the whole aggressive debate side of the things, loved the energy all of you came with. I think we had little moments of us giggling while, listening to your rebuttals. So it felt very nice to. I went back to my college days and it was fantastic, to be honest. And yeah, so coming to the feedback bit, I think Ms. Kriti also very nicely pointed it out. Let's structure our arguments in a manner that it looks backed by some sort of evidence and not just I read this somewhere. So it becomes more like I saw a reel and this is what it is. So instead of doing that, maybe back it up with a little more of what have you read and where. It need not always be very specific. I understand while debating it's very difficult to go back to the exact words of the case or probably the exact party details, but at least uh, give a reference in a manner that your arguments come and flow from those cases that you're referring to. Like the OpenAI case, for example, I keep forgetting the other party all the time. But while talking, also it's very essential that whatever arguments are being told from the perspective of both sides, you present it. Another interesting take would be to use the other side's argument, but twist it for your own benefit. Like this was said in that case which is against your round, but you can twist the words saying that, okay, while that was said in XYZ case, this is what is my opinion to support my case in this example. Okay. So this is one thing I would want to say. Another thing is, while we are at it, I saw a lot of EU references, but very less of US examples. US examples in this case will help both the parties to back their arguments massively. So I think recently there's a copyright from their office. There is a circular which said that no amount of human prompts, even if it is there are human involvement, there is no copyright protection when it comes to the AI generated content. So that becomes a very, very strong case for both the sides. You can use those arguments to, battle for and against. So that would be one. So read up more on US. I'll also go back and brush up my, arguments from both ends. So yeah, very well done. And yes, very charged up. Very lazy Sunday afternoon became very charged up session of, you know, tackle this argument right now because I thought you said this, but okay, I am trying to say this. So it was very well done. It was very good experience. Yeah, please. Yeah.
Thank you so much, ma'am, for your feedback. I would now like to request Ms. Rishita to kindly go ahead with the feedback. But I would also like to first request ask Ms. Nisha, is she able to edit the scores as of now?
Actually, I'm
Sorry,
unable
ma'am.
to access. Please, can you just help me out? I'm not able to access the sheet. Can you just ping me a WhatsApp number so we'll share the score over that if that works?
Sure, ma'am. Sure, ma'am. You can even email us if you're comfortable with it. You can email it to us.
Yeah, works.
Thank you so much.
Okay, fine. I'll do that.
Thank you, ma'am. Ms. Rishita, I'm so sorry for the interruption. You may please go ahead.
Well, first of all, thank you for having me in panel. And it was very enlightening to listen these participants. And I'm really impressed by their arguments. And it's kind of very tough to come up with one after other argument when one party is stating something, another want to tell something else. So I it was overall good, but I think in somewhere the cases and the particular section reference was missing, and they would have included. Sorry, am I audible? Okay, so they would have added reference of section 51 of Copyright Act, which state that infringement can only be done by a person. It is specifically state that person. So Indian law are far behind US, and if we speak about US and other China and EU countries. So yeah, overall it was good, but would have been corrected if the laws and more cases like with exact references would have been added by parties. So yeah, all the best.
Thank you so much, ma'am, for your feedback. I would now like to request Ms. Nisha to kindly proceed with her feedback.
So, firstly, thanks a lot for having me as a judge. It was really great to get a chance to meet some such young enthusiast lawyers. The debate was like outstanding, I would say. The knowledge which they have is incredible at this point. But again, as Kriti, Rishita, and Anwesha has already pointed out correctly, that their legal points needs to be focused on. So, supposedly, as they mentioned the Sophia case, they didn't mention the date of case. Like, if it is a case or citation needs to be there, all those things are have a idea, a rough idea of AI, or is keeping a track of on AI updates, they would know that something like this is going on in the industry. But you or we being a lawyer, that's where we that's what is the distinguished factor when it comes to a lawyer or law students. So that's something which you guys needs to just keep a slight focus on when you are argumenting, because see, supposedly one speaker two said from the T4 that this is the case, then again T5 team told that such case doesn't exist. I'm just giving a scenario. So if you keep a backup with citation and all, then it gets very difficult to counter it, right? So that's something, if you keep a focus on, I think it's good to go. You all are like, you have done an outstanding job. So that's it from my side. I think all my co-panel members have already covered all the points, so I won't take much time. Thank you.
Thank you so much, ma'am, for your feedback. I'm sorry to say this, but we will not be able to declare uh, the winner and runner-up, best speaker and rebuttalist as of now, as the judges are yet scoring the Excel sheet and all your performances. So I would now like to go ahead with with concluding this competition. As the final arguments fade and the echoes of intellectual engagement subsidize, we reach the culmination of this remarkable grand finale of the AI and IUPR debate competition, organized with immense dedication by UPLRC. We extend our deepest gratitude to our distinguished panel of judges, Ms. Rishita Pandey, Ms. Kriti Goyal, Ms. Nisha Pasari, and Ms. Anwesha Banerjee. Their profound expertise, insightful observations, and meticulous evaluation have been instrumental in guiding this final round and recognizing the exceptional talent before us. Furthermore, we wholeheartedly commend the extraordinary efforts of the finalists, their intellectual prowess, rigorous research, and eloquent articulation on the complex issue that has been truly inspiring. They have demonstrated a remarkable ability to navigate intricate legal and technological landscapes, offering perspectives that will undoubtedly contribute to the ongoing discourse in this critical area. With profound gratitude, we also extend a special note of thanks to our esteemed National President, Vaishnavi Ma'am, and her unwavering support and visionary leadership. We deeply appreciate the tireless dedication of Prashansa Ma'am, a National Legal Council member and UPLRC mentor, Khushi, our esteemed State Vice President, and a sincere thanks to Kashish, a valuable Council member, and to all committed members of UPLRC Council. Their collective efforts in conceptualizing uh, and executing this entire competition, culminating in this grand finale, have been truly instrumental in making it a resounding success and a meaningful learning experience for all. As we conclude this grand finale, we encourage you to remain connected with the UPLRC and stay informed about our future initiatives by following us on our official social media handles. Thank you for your enthusiastic participation and engagement in this enlightening event. We look forward to continuing to foster such platforms for critical dialogue and intellectual growth in future. Thank you and have a great evening ahead. The participants are requested to leave. If the judges have any queries with regard to the judging criteria, they can ask.